For most Americans, naturalized citizenship is the most permanent and most secure immigration status that exists in this country. You go through the process, you take the oath, and from that day forward, you are an American citizen with the same fundamental rights and protections as anyone born on American soil. At least, that is how most people understand it. But there is a legal mechanism, one that is now receiving more attention and more enforcement energy from the federal government than at any point in recent memory, that can strip a person of their United States citizenship after they have received it. It is called denaturalization, and while it has historically been used rarely and in the most extreme cases of fraud or serious criminal conduct, the current administration has dramatically increased its focus on identifying and pursuing denaturalization cases. The Department of Justice has expanded its denaturalization unit. USCIS has created new operational resources dedicated to this work, and the number of denaturalization cases being pursued in federal courts has increased significantly. For the vast majority of naturalized citizens who obtain their citizenship lawfully and honestly, this development does not represent a personal threat. But understanding what denaturalization is, what the legal standards are, what triggers a case, and what rights exist for citizens who are subject to this process is information that every naturalized citizen and every person working toward naturalization deserves to have. That is exactly what we are covering today. Hello, everyone, and welcome back to U.S. Benefits Update. I am your host, Claire Hollister, and thank you so much for being here with us today. This channel covers the full range of government programs, immigration updates, and legal changes that affect the financial lives and futures of Americans and immigrants in this country. Today's topic sits at the very heart of what citizenship means, what protections it provides, and under what limited and specific circumstances those protections can be challenged. This is a topic that generates significant anxiety in some quarters of the immigrant community, and our goal today is to replace that anxiety with accurate, complete, and clearly explained information. Understanding the real legal landscape of denaturalization, including both the legitimate cases that the government pursues and the protections that exist for lawfully naturalized citizens, is the best antidote to the fear and misinformation that surrounds this topic. Please stay with us all the way through because every section of this video contains information that contributes to a complete understanding of this issue. Here is what is happening right now and why this topic has moved to the forefront of immigration policy discussions. The Department of Justice, through its Office of Immigration Litigation, and the Department of Homeland Security, through USCIS's Fraud Detection and National Security Directorate, have both significantly expanded their focus on and resources dedicated to denaturalization cases. The DOJ's Denaturalization Unit, which had operated with limited staff and a relatively small caseload for many years, has been expanded and given additional resources and a stronger mandate to identify and pursue cases where citizenship was obtained through fraud or where post-naturalization criminal conduct provides grounds for denaturalization proceedings. USCIS has also been engaged in systematic data matching and record review projects that are designed to identify discrepancies between naturalization applications and information in other government databases, including criminal justice databases, immigration databases, and records from foreign governments. One of the most significant of these projects involved identifying naturalized citizens whose fingerprints matched those of individuals who had previously been deported under different identities, suggesting that these individuals had re-entered the country, used a false identity to naturalize, and thereby concealed their prior immigration history from USCIS. These systematic review efforts have generated a pipeline of potential denaturalization cases that is substantially larger than what the government was pursuing just a few years ago. The current administration has framed this increased denaturalization focus as an integrity measure, arguing that citizenship obtained through fraud is legally invalid and that the government has both the right and the obligation to correct the record when fraud is discovered. Critics of the expanded focus have raised concerns about whether the resources being devoted to denaturalization are proportionate to the actual scope of the fraud problem and whether the pursuit of these cases creates a chilling effect on the naturalized citizen community more broadly. We will address both of these perspectives thoroughly as we move through today's coverage. To understand what denaturalization is and why it exists as a legal concept, we need to look at the foundational principles of citizenship law in the United States and the historical context in which the denaturalization power developed. Denaturalization is not a new concept or a recent policy invention. It has been part of American law for more than a century, and its origins reflect the specific circumstances and legal frameworks of different periods in American history. The legal authority for denaturalization is rooted in the principle that naturalization is a legal process, and like any legal process, it can be challenged and potentially voided if it was obtained through fraud, mistake, or in violation of the law. This principle is analogous to other areas of law where legally obtained rights or benefits can be rescinded if it is discovered that they were obtained through misrepresentation or illegal conduct. In the immigration context, the specific statutory authority for denaturalization is found in Section 340 of the Immigration and Nationality Act, which provides that a certificate of naturalization that was illegally procured or procured by concealment of a material fact or willful misrepresentation may be canceled, and that the person's citizenship may be revoked. The phrase illegally procured covers situations where the person did not actually meet the substantive requirements for naturalization at the time it was granted. For example, if they were not actually a lawful permanent resident when they naturalized, or if they had criminal convictions that should have made them ineligible. The phrase concealment of a material fact or willful misrepresentation covers situations where the person met the technical requirements, but obtained citizenship by lying about or hiding information that would have been relevant to the naturalization adjudication, such as a prior deportation order, a false identity, undisclosed criminal history, or membership in a prohibited organization. Historically, denaturalization was used most extensively in the decades following World War II to strip citizenship from individuals who had been members of Nazi organizations or who had committed war crimes before immigrating to the United States. The Office of Special Investigations, which was created within the Department of Justice specifically to pursue these cases, brought denaturalization proceedings against dozens of individuals over several decades, successfully removing citizenship from individuals who had concealed their Nazi past and war crime participation when they immigrated and naturalized. These cases established important legal precedents about the standards and procedures for denaturalization that continue to govern how such cases are conducted today. Let us now be very specific about who is and is not subject to denaturalization, because precision here is essential for replacing unfounded fear with accurate understanding. The legal standards for denaturalization are specific, demanding, and limited, and the vast majority of naturalized citizens have absolutely nothing to worry about from the current enforcement focus. The primary category of individuals subject to denaturalization consists of those who obtained citizenship through material fraud or misrepresentation. This means people who actively lied on their naturalization applications about facts that were relevant to their eligibility, and where the lie was about something that actually mattered, not a minor or inadvertent error. Examples of material misrepresentation that can support denaturalization include lying about a prior deportation order or immigration violation, using a false name or false identity throughout the immigration and naturalization process, failing to disclose a criminal history that would have made the person ineligible to naturalize, falsely claiming to have met the continuous residence requirements when the person was actually living primarily abroad, and failing to disclose membership in organizations or affiliations that would have been relevant to the good moral character determination. The second major category covers situations where citizenship was illegally procured without fraud, meaning cases where the person received citizenship despite not actually meeting the legal requirements, through an error in the adjudication process or through circumstances that made the grant legally invalid. This category is narrower and more complex than the fraud category, and cases in this category are relatively rare compared to fraud-based denaturalization cases. It is critically important to emphasize what is not grounds for denaturalization, because this is where the most significant misunderstanding exists in the broader conversation about this topic. Criminal convictions after naturalization, with a very limited exception for cases involving treason or certain specifically designated crimes, are generally not grounds for denaturalization. A naturalized citizen who commits a crime after becoming a citizen faces criminal prosecution and incarceration through the criminal justice system, not denaturalization. The fact of having a criminal record after naturalization, even a serious one, does not strip a person of their citizenship except in the very specific statutory circumstances involving crimes connected to the fraud in obtaining citizenship or certain extraordinary crimes like treason. The common misconception that any serious crime can result in denaturalization is incorrect as a matter of law. Understanding how the denaturalization process actually works procedurally is important for anyone who wants to fully grasp what protections exist for naturalized citizens. Denaturalization is not an administrative action that the government can take unilaterally by simply deciding to revoke someone's citizenship. It is a judicial proceeding that must be conducted in federal court, and the citizen has the full panoply of constitutional rights that apply in federal civil proceedings, including the right to notice, the right to be heard, the right to present evidence, and the right to appeal. The government bears the burden of proof in a denaturalization proceeding, and that burden is substantial. The government must prove its case by clear, convincing, and unequivocal evidence, which is a higher standard than the preponderance of the evidence standard used in most civil cases. This heightened burden of proof reflects the profound consequences of denaturalization and the constitutional importance of citizenship. Courts have interpreted this standard strictly, requiring that there be no fair or reasonable doubt about the fraud or illegality before citizenship can be revoked. The high evidentiary standard means that denaturalization is genuinely difficult for the government to achieve, even in cases where there is significant circumstantial evidence of fraud, if that evidence does not rise to the level of clear and convincing proof. A person who is the subject of a denaturalization proceeding has the right to legal counsel, and given the stakes involved, having qualified legal representation is absolutely essential. The government is represented by experienced federal attorneys from the Department of Justice, and a person facing denaturalization without legal assistance is at a severe disadvantage. Several legal aid organizations and nonprofit immigration law firms provide representation in denaturalization cases, and anyone who receives any communication from the federal government suggesting that their citizenship may be under review should treat that communication as requiring immediate legal consultation. The timeline of the current denaturalization enforcement push and what it means for naturalized citizens who are going about their lawful lives is important context for understanding the practical significance of these developments. Let us look at where things stand now and what the trajectory looks like going forward. The expansion of denaturalization enforcement activity under the current administration began in the early months of 2025 and has continued to intensify through 2026. The DOJ has been filing new denaturalization cases at a rate that exceeds what was observed in any comparable period in the recent past, and USCIS has been completing its systematic data matching reviews and referring cases to the DOJ for prosecution on an ongoing basis. The pipeline of cases that has been developed through these systematic review efforts is expected to generate additional filings over the coming months and potentially years. For naturalized citizens who are wondering whether they should be concerned, the most important thing to understand about this timeline is that the cases being pursued are not being selected randomly or broadly. They are being developed based on specific evidence of fraud, identity discrepancies, or other legally significant irregularities that have been identified through this systematic review process. A naturalized citizen who obtained their citizenship lawfully, who did not lie on their application, and who does not have the specific types of undisclosed prior history that are targeted in these cases is not at risk from the current enforcement push, regardless of their national origin, their political views, or any other factor. Legal scholars, civil liberties advocates, and immigration policy experts have offered extensive commentary on the current denaturalization enforcement push, and their perspectives help illuminate both the legitimate legal basis for this enforcement activity and the concerns that have been raised about its scope and implications. Constitutional law scholars who specialize in citizenship and immigration have noted that denaturalization, while legally authorized and constitutionally permissible in cases of fraud, represents one of the most severe deprivations of civil status that the legal system can impose, and that the heightened procedural protections that surround it reflect the gravity of that consequence. These scholars support the enforcement of the law against genuine fraud cases, but have raised concerns about the potential for overreach in a political environment where immigration enforcement is a high-profile priority. They emphasize the importance of the clear and convincing evidence standard and the judicial oversight that must accompany any denaturalization proceeding as the key safeguards against inappropriate use of this power. Civil liberties organizations, including the ACLU and various immigrant rights organizations, have expressed concern about the chilling effect that heightened denaturalization enforcement can have on the naturalized citizen community, even among those who have no legitimate basis for concern about their own citizenship. When naturalized citizens fear that their citizenship is less permanent or less secure than they believed, that fear can affect how they exercise their constitutional rights, including their right to political speech, their willingness to engage with government agencies on other matters, and their sense of belonging and security in the country they have chosen as their home. These organizations argue that any legitimate enforcement against genuine fraud cases should be accompanied by clear public communication about the specific and limited circumstances in which denaturalization applies, to prevent the kind of broad-based anxiety that does not serve any legitimate policy purpose. Let us look at how the current denaturalization enforcement focus is actually affecting real people and communities, because the human dimension of this story has multiple facets that deserve careful and honest attention. For the small number of individuals who are actually the subject of denaturalization proceedings because they obtained citizenship through genuine fraud, the proceedings are a serious legal matter with potentially life-altering consequences. A person who is successfully denaturalized loses their citizenship, potentially reverts to lawful permanent resident status or to no status at all depending on the circumstances of their case, may be placed in removal proceedings, and loses all the rights and benefits that citizenship provides. The loss of citizenship also affects spouses and children who may have derived benefits from the citizen status, creating collateral consequences that extend beyond the individual who is the subject of the proceeding. For the much larger population of naturalized citizens who are not subject to any denaturalization proceedings and who have no legitimate basis for concern about their own citizenship, the practical impact of the current enforcement focus is primarily psychological and political. Community organizations that serve naturalized citizen populations report increased anxiety and questions about citizenship security, with some community members expressing concern about whether their citizenship could be challenged despite having obtained it lawfully. Immigration attorneys report an uptick in calls from naturalized citizens who want reassurance that their citizenship is secure and who have questions about what kinds of records or information the government is reviewing. For people who are currently in the naturalization process or who are considering applying, the current environment creates an incentive to ensure that their applications are complete, accurate, and thoroughly documented. This is, in a sense, exactly the right response to the current enforcement focus. A carefully and honestly completed naturalization application, supported by complete and accurate documentation, provides the strongest possible protection against any future challenge to the validity of the naturalization grant. Immigration attorneys who work with naturalization applicants have been emphasizing the importance of full disclosure and complete documentation in the current environment. And this guidance serves both the immediate interest of the applicant and the long-term security of their citizenship. Let us close with a clear, complete, and accurate summary of everything we have covered today. Denaturalization is a legal process by which a federal court can revoke the citizenship of a naturalized citizen who obtained that citizenship through fraud, material misrepresentation, or illegal procurement. It is authorized by Section 340 of the Immigration and Nationality Act and requires a full judicial proceeding in federal court. The government must prove its case by clear, convincing, and unequivocal evidence, a high standard that reflects the gravity of revoking citizenship. The person who is the subject of a denaturalization proceeding has full constitutional rights, including the right to legal counsel, the right to present evidence, and the right to appeal. The current administration has significantly expanded the resources and focus devoted to denaturalization enforcement, primarily targeting cases where systematic data matching has identified evidence of identity fraud, concealed deportation history, or other material misrepresentation in the naturalization process. The overwhelming majority of naturalized citizens who obtain their citizenship lawfully and honestly are not at risk from this enforcement focus. Criminal convictions after naturalization are generally not grounds for denaturalization except in very specific statutory circumstances. Anyone who receives any communication from the government suggesting their citizenship may be under review should consult with a qualified immigration attorney immediately. Before we wrap up today, we want to hear from you. Do you have questions about the denaturalization process or about what protections apply to lawfully naturalized citizens? Are you a naturalized citizen who wants to better understand the security of your citizenship status? Do you have questions about the naturalization process itself and what you can do to ensure your application is complete and accurate? Drop your questions and your thoughts in the comments section below. This is one of those topics where accurate information is genuinely important, and the conversation in our comments can help members of our community replace fear and uncertainty with knowledge and confidence. If this video helped you understand denaturalization more clearly and gave you information that is useful for your own situation or for someone in your community, please give it a thumbs up and share it widely. Subscribe to US Benefits Update and turn on your notifications so you never miss a video that covers the immigration and citizenship topics that matter most to you and your family. I am Claire Hollister, and thank you so much for watching today. We will see you in the very next video.